Everybody, thank you so much for joining us for our industry update this month. I'm Jill Cox with Heritage Title. Super excited to have you all here and really thrilled for our guest speaker today. It's going to be a really exciting topic. Before we introduce our guest today, I would like to make sure everybody is aware of some of the upcoming updates that we have. So make sure and save the dates. These are always the first Thursday of every month at 2 o'clock. Our one next month for October, it's going to be Damian Cox. He's the vice chairman of the Forms Committee. So he's going to be talking about all the forms changes that are going to be going into effect in 2022. So definitely join us for that one. It's going to be full of really great information. November 4th, Paul Bondi is going to be back on. He's an E&O insurance broker. So he's going to be talking about E&O coverage for real estate brokers specifically. So definitely don't miss that. And then December 2nd, we just secured Suzanne Leff, who is an attorney who represents HOAs and is very familiar with some of the HOA legislation that's new and going to be affecting HOAs and how our business is done. So definitely join us for that one as well. And with that, drum roll, please. Welcome to Merc Pittinos. We are so thrilled to have you on today. There was such a great response to this subject. Everybody wants to hear all the gory stories about buyers and sellers suing one another. So let me just give a quick intro about Merc and his background, and then we'll kick things off here. So Merc is a real estate litigator with Moy White. He focuses his practice on helping clients resolve real estate related disputes. He works with developers, landowners, landlords, brokers, and homeowners. He helps clients resolve disputes involving real estate transactions, loans, leases, easements, covenants, and boundaries. He's written and lectured extensively about Colorado adverse possession law, and he's represented clients in jury trials, bench trials, and arbitration proceedings, and has argued cases before the 10th Circuit Court of Appeals, the Colorado Supreme Court, and the Colorado Court of Appeals. So very busy guy, Mark. We cannot thank you enough for taking time out of your extremely busy schedule to join us. We are really looking forward to hearing what you have to say today. So with that, I'll turn it over to you, and thank you so much again.
Sure. Thank you, Jill. I really appreciate the chance to be able to talk to you all today. Jill, thank you to your team at Heritage Title for having me. This is just it's a great resource that you're providing to the real estate community, and really appreciate the chance to be part of it. When we were talking about getting prepared today, there were really two main things that I thought would be helpful to talk through. One is just to be able to give you all a better sense of what it's like from the lawyer's perspective when you're dealing with a real estate dispute, so that when you get to a point where you have a conflict, that it's easier for you to be able to prepare your clients for how to work with a lawyer, and to give you some tips and tricks for getting them prepared for what the experience is like, and what to anticipate, so that when they have to reach out to a lawyer, they're better prepared and you're in a better position to win. The second thing that we're going to talk about is just ways that you can help your clients avoid getting into litigation, and through the transaction process, steps that you can take to put them in the best possible position, so that if they have a dispute, that they're in a position to be able to win. So starting out, when the types of real estate disputes that I work on are all over the map, and as you guys might expect, because of the volume of real estate transactions that have been happening in the metro area over the last couple of years, the number of disputes that have occurred have ticked up in a significant way. So one
that's a nice way of saying it. Ticked up in a significant way.
They're just, David and I were talking about it before, and they're just a lot more disputes. Part of it is because people are paying. We joke that there's just a lot of angst right now, and so when people encounter a problem, they tend to be more intense about it than they may have been in years past. The price of real estate has increased so significantly that when people buy, their expectation for what they're paying is that there won't be a problem. and even and when there are, they expect somebody else to take care of it, especially when they've just bought a property. So there really are three different times when I have clients that are reaching out to me. One source of disputes that historically I did not see a lot of, but have been occurring more frequently, are people that are just refusing to close. So that's not something that I was involved with, just didn't have a lot of those kind of disputes. And now, either because people are on the selling side realize after they go under contract how expensive it is or how difficult it is to move, they decide they want to back out of a deal. And then people that are under contract similarly are either finding something else or realizing, well, this is more expensive than what I was expecting, and I want to figure out a way to be able to get out of the deal. So one place where lawyers can be helpful is pushing things along to be able to help get your clients to the closing table. Because once they sign a contract, they're bound by it. And just because somebody wants out doesn't mean that they're allowed to be out.
Merc, I find it funny that you say that where a lawyer can help with a transaction. I bet you most of the brokers on this call are saying, when is a lawyer ever helpful? So you might have to kind of explain that a little bit as to how you deal with those instances and what that looks like. But I don't know if that's later in your presentation, but
well, that's one of the things that I hear about all the time. And that's I think it's one of the important parts about Colorado, that there are billions of dollars of real estate transactions that take place here every year. Almost not the vast percentage of them do not include lawyers, and brokers don't want lawyers involved. And that's one of the things that I hear more often than not, because there are more lawyers that blow up deals than help close deals. And that's one of the important tools that I think one of the points that I wanted to make is that one of the things that is a really worthwhile investment for each of you is the last thing you want to do is send a client out to the internet to find a lawyer. And so on the on the front end, in the same way that you have a list of preferred inspectors that you've vetted and checked out, you want to have lawyers also that you either have friends that are brokers or your managing broker has referred, so that once you get into a deal where there's a problem, you have a lawyer that's somebody that helps facilitate a deal instead of blowing it up.
Yeah, it's funny, Merc, there was a chat that just came in that says, we really love the family divorce lawyer involved with the real estate transaction. So, that can't be overstated. I mean, the brokers, you guys have referral lists for title companies and your preferred lenders and the inspectors and appraisers sometimes when that comes up and all these different things. A lawyer isn't a bad one to have either, and know how that lawyer is going to work in that transaction. I mean, Merc's going to tell you he has an obligation to your client. He has an obligation to look out for their best interest. At the same time, suing people is not always their best interest, even though I think some lawyers look at it as that's what their job is to sue everybody and see what happens. So
that's exact. So that having that kind of list of people in advance of a problem is really helpful. One of the things that makes selection difficult is that there are a lot of people that say they're real estate lawyers that have that dabble in it, but really aren't real estate lawyers. And so taking time to be able to vet people to find someone that really that spends the vast majority of their practice in real estate is something that's a huge value to your clients.
Hey, Merc.
Yeah.
Sorry, we had somebody ask the question, how do you select or interview an attorney? How does somebody build up those relationships and identify who is good and who's not?
Okay, so that's the way that I think about that is that when someone goes out to find a real estate broker, it's referral based. And so the easiest way is to talk to people that are either in your brokerage firm or your managing broker. And then a couple of things that I think are important is that in the same way that when you all are paid a commission, there are some people that provide significantly more value for the same dollar in commission. The same thing holds true for lawyers. And so I think one thing is you don't want to find your lawyer on the internet. The second is don't necessarily make the choice based on what their hourly rate is, because what you really want is to talk to a lawyer about what do you think the total cost will be for a particular project. So if you have a dispute, you need a letter written. I can tell people pretty clearly, I've written this letter a lot of times. Here's what I think it's going to cost. And I can write a letter, and even though my rate may be higher than somebody else, I can write the same letter in half the amount of time. So it shouldn't be something that's driven by the hourly rate, but really what's the value that you're going to be receiving. And that's the best place to look is referrals, and to be able to talk to somebody and say, what was the experience like working with this lawyer? Were they somebody that helped facilitate the deal, or somebody that blew it up? And what's their personality like? Is their personality, do they feel like someone that wants to just fight, or are they somebody that wants to be able to, that's practical and wants to get things accomplished? And so those are the kind of things that you're thinking about when you interview. Not is this person a bulldog? Because the person that's a bulldog oftentimes is the person that makes things more complicated, more expensive, and makes deals harder to get done.
And that's a good point too. Absolutely.
Then, so that's so one way that kind of coming back to where we were. One way that a lawyer can help out is you have a conflict. Somebody says, I don't want to close. Then you have a lawyer send a letter saying you have to close because you're under contract. You don't just get to unilaterally terminate because you don't feel like going forward with the deal that you signed up for.
And those, Merc, you've written a lot of those letters, and those are fairly effective when you got a seller that gets stuck, aren't they?
They are. And the reason that they're effective, to me, when I'm thinking about, to answer that question, is it effective? To me, when I'm approaching a real estate problem, what I'm thinking about is the value of the legal services that I'm providing, does that provide a multiple of benefit? So if someone pays me $500 or $1,000 or $2,000 to work on a project, the way that I view it is that should be providing $5,000 or $10,000 or $20,000 in value. It's not really that helpful to spend $1,000 on a lawyer to get $1,000 in earnest money back, or to end up in the same place that you were to begin with. So something like closing a deal, the first answer is the amount of money that you have to spend versus the benefit that you receive is significant. The second point is that there are a lot of people in the course of a transaction, when a dispute starts to come up, that say, I'm going to get my lawyer involved, and it's really not a serious threat. The benefit of having a letter, and even a short letter, is it says we're serious about closing, and if you don't close, we already have somebody engaged to be able to facilitate it. And that's why it's so effective, because instead of just saying, if you don't close, we're going to get a lawyer involved, you show that you're serious about it.
Somebody just asked the question, how do you feel about companies such as Legal Shield for disputes?
I don't even know what it's embarrassing, but I don't know what Legal Shield is.
Merc, that's a prepaid legal service. And I mean, and some of those things are half effective. It's just, they also don't do real estate. They do wills, and they do probate, and they do, injury, and they do insurance, and they do a little of everything. Sometimes you get what you pay for is I hate to hack on anybody in particular, but it's just, sometimes they can be effective, but I mean, I deal with specialist lawyers all the time, guys. So I'm going to tell you that I would want a specialist for any kind of dispute that comes up. You get more bang for your buck, is my feeling.
And then I have actually run across that type of service before, and sometimes it's part of a pension that someone would have, or part of retirement benefits. And now that you mentioned, my experience has been that they don't help out on real estate disputes typically. The other part of it is that somebody that's been involved in the legal community for a long time and has relationships with other lawyers, in the same way that when you have a deal with a broker that you've known for a long time, any kind of issues get worked through much more quickly. The same thing goes for lawyers. So if you're finding someone that's just moved to Colorado, they're going to have a much more difficult time facilitating a deal than somebody that's been practicing law here for 20 or 30 years. So another, the other place where I see kind of two other times when people get lawyers involved. One of them is really simple. If the other side has a lawyer that gets involved, and you have a letter from a lawyer and you know that it's not just a fake threat, but there really is somebody on the other side, that's one point where you want to bring somebody in. And then the second, the place where I see most disputes coming up are disclosure disputes that come up after closing. That's the number one type of dispute that I see over and over again. And those are—
Merc, would you mind just kind of explaining how you see that dispute come up? I mean, the brokers that are on this, I've heard that a million times about, adverse material facts or disclosure issues, but from your perspective, what is it that it looks like when a buyer makes the claim?
Okay, so when a buyer makes the claim, in my experience, they fall really into three different categories. So what will happen is that the buyer will discover a problem after closing. It could be an issue with the roof. It could be an issue with the sewer line, a mold issue, a solar panel issue. And the other common one that I see a lot is issues that relate to some kind of flooding in a property. So a buyer would buy a house, then start to do work, discover problems that weren't disclosed. And then when they find out how expensive it is to remedy, then they go, okay, this looks like a situation that the seller knew about and should have disclosed on the form. And in my experience, they fall into three different categories. There are people that just lie on the disclosure forms, and they do things like perform work without a permit and then lie on the disclosure form. They say everything is compliant with HOA regulations when it's not. They say that everything is code compliant when it's not. I think that's a small number. It's a small percentage of people that just flat out lie on disclosure forms. Then most of the disclosure issues that I see fall into a gray area, where it's a he said, she said type of dispute, where someone looks at a problem like there could have been a flooding or some kind of water leakage problem in a house, and there's evidence that there's some sort of stain where you go, okay, there was a problem here. And the buyer automatically assumes that because of something else that was done, that the prior owner knew about it. And that may not be the case at all. Could have been something that they never knew about, could have been something that happened with a prior owner. Or it could have been something that they absolutely knew about and just didn't disclose. And that type of situation, sometimes it's an honest mistake because of the pressure of real estate deals. You decide to list your house and you have to fill out the seller property disclosures. You maybe have 24, 48 hours to do it. You've lived in a house 15 or 20 years. There's a good chance you forget things, and it's just an honest mistake. And in those kind of situations where it's a gray area, the way that I see people react to it is one of two ways. Either they admit and they say, you know what, that was absolutely a problem. I missed it. I'm going to take care of it. I'm going to do the right thing and pay to fix the problem. And then there are other people that respond and say, I had no idea what you're talking about. And that wasn't, that I never knew that existed, and I'm not going to pay you anything. And those are the conflicts that I see more often than not. And they're the most difficult to deal with because there's not a document, there's not an email or a picture or a permit that enables one side to say that the other side is lying. And those suits get to be really expensive, and it's really hard to figure out who's right and who's wrong. And in that type of situation, what I tell people more often than not, and I think this is helpful advice to tell your clients, is that the first place to start is just a cost benefit analysis. What's the problem? How much is it going to cost to fix? And if I bring in a lawyer, what's the likelihood of recovery, and how much is it going to cost cost to get there. And for a lot of disputes that are $5,000 or less, the advice that I tell people is it's not worth you spending money on legal fees to fix it, even if you're 100% right, because of the aggravation of fighting with somebody else, the time that it takes and the energy. You're probably will be better off financially at that threshold of just fixing it and moving on, making sure that it's done right than fighting with somebody. And once you get above that threshold, then it makes sense, especially if it looks like someone is not telling the truth, to try and push things a little bit farther.
Merc, you had mentioned the other category where the seller says, oh gosh, it was an honest mistake, I blew it, I'll take care of it. Do you ever end up involved in those kind of settlements of disputes, or do they take care of it themselves? Or, my concern is always that the brokers end up being involved in that discussion. And then you got this, okay, well, what's the resolution going to look like? What's the agreement going to look like? And that gets concerning because it's outside of a transaction. We're talking about, if they start drafting stuff, obviously we're into the world of practicing law without a license. So have you ever dealt with those kind of things at all? Or do you see that come up at all, or any suggestions?
So that, in those kind of resolutions, one way that I see people deal with it is one side just agrees to pay the other, and there's no formal agreement, and everybody just moves on and forgets about things. If you're writing a check, though, most people want a release in exchange for the check, and that's something where you really want a lawyer involved. So if I'm a seller and a buyer contacts me and I say, okay, it's better to settle than to have a dispute, I'm going to pay you $5,000 to resolve it. What I would want as a seller is a settlement agreement with a release of claims, which means if I pay you $5,000 to settle the dispute, I want a release from you that says, most importantly, that the buyer cannot sue me again for anything else related to the sale of the home. And what that means is if we had a settlement on a mold issue and later on there is a structural issue that's discovered, the buyer can't come back and sue me again. And that's something that you absolutely do not want to pull off the internet. It's something that you want to make sure that a lawyer's drafted. And there really are two different reasons why. One, you want to make sure that it's done correctly. And then the second, which you all hear all the time, is you're not supposed to be drafting contracts. You're not supposed to be drafting settlement agreements. And even though it's less expensive for your client, it puts you at risk and it puts them at risk.
Now, the thing that I'll tell you that a lot of these guys are going to say is, yeah, but my client doesn't want to pay a lawyer to draft anything. So, for you guys out there that are thinking that right now, I'll tell you, make sure you put in writing and suggest that, hey, if you're paying money on this settlement, you probably should talk to a lawyer about drafting a settlement agreement and putting something in place to make sure this is the conclusion of this matter. So I get that clients don't like to spend the money. I get that, but make sure you protect yourself by at least sending something in writing suggesting that they should hire somebody, even if they don't. I mean, frankly, we all know we'd rather they hire Merc and get it done correctly, but there are people that just aren't going to want to pay it. So protect yourself by at least suggesting that that is what they should do, even if they don't.
That's great advice. That's probably something that you can't do enough. And that's I think one of the most important points is that when someone comes to me about a real estate dispute, the way that the way that any kind of problem is analyzed, if for example it's a buyer and they come to me and they go, okay, no matter what sort of real estate problem it is, there typically are three different people that could be responsible. So either nobody's responsible, or there really are typically three different people. One would be the seller, the second is the brokers, and the third is a title insurance company. And brokers become easy targets because people generally know that they have insurance, and people think that if they sue a broker or bring a claim against a broker, that it's going to be picked up by insurance and it's going to be an easy payday.
Yeah,
Most of the time-
they think sometimes that doesn't go as easy as they think it does, because there's a whole process for E&O insurance and going through it. But that's I will not put you in this category, Merc, but that's the plaintiff's process thinking, is that, oh, we'll just name the brokers and somehow get a check magically. So
and it doesn't work out that way. And it's also, so those are the three typical targets. And usually it's, you go, okay, there's only one of those, two of them, title insurance company and the insurance company that's providing E&O coverage. Those are the two biggest sources of money that are out there. So let's go after those. And that's why making sure that on something like a settlement agreement, you're providing notice to your clients, so that no matter what happens in that settlement agreement, if they choose not to hire a lawyer, you're not going to be held responsible for a mistake that they made. I think another thing that I was thinking about that would be really helpful for in preparing your clients to talk to a lawyer. When somebody calls me up, what they're mostly concerned about is the problem. So they've just had a sewer line back up, or the air conditioner stopped working, or they found a structural problem, and the clients want to talk about that. And the issue with lawyers is that because of ethical rules, we have to go through a process where we check and make sure that we don't have conflicts. So a lot of times people will call me up, and I think that they think that I'm being short with them or their clients. And it's not that I'm not interested in the problem or want to hear about it, but as a lawyer, you can't really get into the details of what someone's working on until you figure out whether or not you have conflicts. So it's really helpful to tell your clients in advance that the engagement process and what to expect is one really short call, so that the lawyer has enough information to figure out if they have conflicts, and then a second follow-up call where you talk through the background of the dispute. And helping clients get ready for that is helpful, because it can be a little intimidating to call a lawyer. And when you do, and you have a response that's sort of short, not because the person isn't interested, but because of ethical rules that they can't engage, it's helpful to get somebody ready for that. The next step is that in all of the disputes in almost every dispute that we've talked about, whether it's a how do we get to closing type of dispute or a property disclosure dispute afterwards, they're all really fact specific. And so it takes time for lawyers to be able to understand exactly what's going on. So the things that you can do as a broker to be able to help facilitate that process is, as soon as your client is reaching out to a broker, making available to your client or sending directly to the lawyer all of the documents that are part of the relevant documents that are part of your file. And generally what that will be is the contract, any amendments, extensions, inspection objections, resolutions, and any other documents that you have that relate to the dispute. The way that the brokerage process works now, things are moving so quickly that my experience is that it's hard for clients to be able to find all those documents, because they're sent at different times. And unless they're really organized, they're not downloading them to a computer. And you all have the ability to compile them all in one email and send them. And it makes the work of the lawyer a lot easier, because then you have everything in one place and you can give feedback to people much more quickly. And explaining that to a client on the front end is really helpful, that there are a group of documents that the lawyer will need to be able to help you out. And I'm going to go ahead and send them to you right now to make this process easier for everybody. That's just a good thing to think about, because it will strengthen your relationship with your client, and help your client through what can be a difficult process of reaching out to a lawyer and getting feedback. Okay, then are there
do you want to answer a couple questions, Merc, real quick while you're transitioning? Would that be okay?
Yeah, that sounds great.
Okay, Jill, do you mind? Do you have them up, or?
Yep, absolutely. So this person's curious about kind of how many disputes between buyers and sellers ultimately end up dragging the brokers into the dispute. How frequently do you see that?
Not that frequently.
Yeah, there's a caveat to that though, because go ahead, Merc, you answer it, and then I got some comment on it too. So
I think so, and maybe what Damien's I think in some ways it depends on the lawyers that are involved. But for the disputes that I'm involved in, for the most part, they don't involve the brokers. And it's in every dispute, it's something that as a lawyer you have to figure out, is this a situation that was created because a broker made a mistake or because a buyer or seller made a mistake? So that's part of the initial investigation, is to figure out, okay, who is it that, why did this happen? And a lot of the disputes that I deal with are not ones that are created by brokers.
yeah, and my caveat to that is it is dependent on the lawyer. I've seen a lot of lawyers that take a shotgun approach to litigation, which is, let's name anybody that could possibly have had anything to do with this. Let's name them in the litigation, and then we'll sort it out through discovery, which to me is a little bit unfair when the claims really lack any sort of merit. But, you know, it goes back to the conversation we had before about a lot of plaintiffs' lawyers, or some plaintiffs' lawyers. And I don't want to lump them all together, because Merc's a plaintiff's lawyer, or has been a plaintiff's lawyer. There's some that know that there's insurance involved. They know that the carrier is doing a cost benefit analysis themselves. How much is it going to cost to litigate it versus how much is it going to cost to settle? And so there are people that try to take that approach to name brokers, even when there may not be a real factual basis for including the broker in the litigation. What's surprising is that it's not as effective as they think it is. A lot of times the insurance carrier does an analysis and does look at it, and they don't like settling claims when there's no basis for the claim. They don't just write checks typically to write checks. They're going to make the plaintiffs and the plaintiff's lawyer jump through the hoops and prove up their claims and hire defense counsel that's going to get involved in it. And if there's nothing to the claims, then they're going to fight it more than they might otherwise. Now, whether they sell it eventually or not is going to depend on the facts and the circumstances, and whether or not the plaintiffs have been able to put together or piece together some kind of claim. But yeah, I do see brokers getting involved, getting dragged in sometimes when they shouldn't be, or a lot of times when they shouldn't be, just because of that approach. And that's one of the reasons, you know, I have brokers that ask me for referrals. Merc is one of the people on my referral list, is because I know his approach is to actually evaluate the case and the substance of the claims. And I'll tell you, Merc will bring them against the brokers if you think the broker screwed it up, but he's going to evaluate whether what it is first. So.
All right, we're going to get to everybody's questions here. So this one, Merc, are you seeing an increase in lawsuits against brokers due to buyers waiving contingencies? For example, the buyer waives or limits their inspection and then finds a post-closing problem and blames their broker.
I'm not seeing an uptick in that. But I think the important part there is when Damien said earlier that if you're going, that the one thing that you can do to protect yourself in that situation is make sure that, so it will be in the contract and it's clear in the contract, but it's also really helpful to have something in writing to say to your client, this is because of the pressure of the market right now, the only way to be able to get this deal done is by waiving contingencies. And here's what that means, so that they can't come back later on and say that you didn't inform them. Because that's one of the risks of being involved in the market right now, because of how much pressure there is. And it means that people are making decisions under pressure, and they find things later on, and then they look for someone to blame. And to me, that question also highlights one of the things that I think is really important as a broker, that because of the stress of deals and the stress that people are under and the time crunch, and because of how emotional a real estate transaction can be for people, it's really important that you guys are the eyes and ears for your clients, because you see so many properties, and it's much easier for you because you don't have emotion in the deal, and because you see so many properties, that you all will notice things that somebody else that has the pressure of a deal and the acquisition won't see. And those are things like, there are things on the outside of the property that you would see, like a fence that doesn't seem like it's in the right place, or something weird about a roof, or something weird about where a driveway or landscaping is located, something that just doesn't fit, where you go, you know what, this is probably a good situation to bring in a surveyor and an expert, where you may have waived contingencies, but, and even though you did that, you really should know what you're getting into before you buy. The same thing goes that when you're on the inside of a home, there always are things that you will see and notice that a buyer won't. And that could be an issue with, it could be a hot water heater. It could be a wall that doesn't seem right, or a door that doesn't close. There are all kinds of things that you all notice because of your experience in homes that they're really counting on you. And the more that you can be the eyes and ears for your clients and not get into a situation where you're relying on the words of the contract, you're going to be much better off and much less likely to have a dispute. And the two things are, when you, number one, when you see something that seems out of place, it's bringing it to your client's attention. And the second is making sure then that they have the experts that they need to be able to evaluate it, whether that's an engineer or an inspector or a lawyer or a surveyor. The investment that you make in building a network of people that can assist in transactions is what will help your clients stay out of conflicts.
I got a couple of things I want to caveat there for you, Merc. But so guys, one thing I do, Merc's saying be the eyes and ears and looking at stuff, and he's right. I mean, if you guys are seeing things in homes, bringing it to your client's attention in writing, not just telling them, because God knows that gets us in trouble more times than I can tell you. But you're also not the inspector. So make sure that you set the expectation with your clients that is not your job to inspect. You do not have a duty to inspect. At the same time, you're balancing this because make sure they know I'm not the inspector. That's not my job. We'll hire somebody else that's a professional. That's their job. However, if you do see things, you guys do see a lot of homes, you do know what's out there. And if you notice something that's a little peculiar, that's when you say, gosh, I just noticed, that fence looks a little strange to me. You may want to make sure that you consult with the surveyor to see if it's in the right place, or you may want to ask the seller if it's in the right place. And this is email again, and for those that don't know, think I'm over here having problems, but that's important. It is a balancing act between the two, because you don't want to put yourself out there that, oh, don't worry, I will go and make sure that this home is perfect. At the same time, you do need to bring it up if you see something that is strange. The other thing I want to, this question started with Eric asking if there was an uptake in claims based on waiving contingencies. And I don't think it's the brokers I haven't seen the brokers being named to them yet, but I will say when Merc talks about the increase in claims for failure to disclose, that is somewhat a byproduct of the waiving contingency. Some of the claims that these buyers are making is, I didn't get a chance to inspect, or they're upset because they overpaid for the property because they put an appraisal gap guarantee in, or something along those lines, which is leading to other claims as well. So don't think that those things don't have an effect on the claims that are being made against brokers or as well as clients, because there definitely is a nexus there.
Okay, can we power through a few more questions? Do we have time? Okay, here's one. So what is the statute of limitations relative to a real estate claim?
So there are two different statutes of limitations that apply. For a breach of contract claim, the statute of limitations is 3 years. So what that would apply to would be if a buyer is bringing a claim that is essentially based on a seller failing to disclose something in the seller property disclosures. That's going to be a breach of the real estate contract. And the event that would trigger the running of the statute of limitations is what's the date that you should have discovered the issue, not necessarily what's the date that you did. But if, for example, there had been flooding in a house that wasn't disclosed, you go to replace the carpet and you pull up the carpet, and then you see that there's all new padding underneath it. And somehow you can tell that that padding was put in within the last year or so. So it would be the date that you discover that there was new padding in. 3 years from that date would be the statute of limitations. With a real estate broker, there are two types of claims. There's a negligence claim, and you could also have a claim that's based on a breach of the listing agreement. So a breach of contract claim there would be 3 years. If it's a negligence claim, it would be 2 years. And just to be safe, if I know that a client has a breach of contract claim based on the sale of a house, I will calculate that 3 years from the date that the contract was signed, so that nobody could ever say that you're outside of the statute of limitations.
We had a question here going back to seller who's wanting to get out of the deal. So what can a client expect to pay for a letter?
Okay, so usually, depending on the complaint, so it usually is somewhere $500 to $1,000 to be able to send a letter. If there is a lot of factual background that takes more time to work through, it can be more expensive than that. But generally, it's in the $500,000 range.
And this is a similar question to Eric's contingency question, but in relation to the huge appraisal gaps. So are we seeing any sales contracts with huge appraisal gaps and values not coming in, and the buyers going back to sue the real estate agent for talking them into the contract with the gap?
Okay, so that's going to be something that is because of the volatility in the market. There really are two things. One, you see appraisal gaps much more frequently, and the second is that is absolutely the sort of thing that you do not want to draft. So when I am talking to brokers, I go, okay, this is anytime that you get into the additional provision section and you start to type in words there, unless it's something, that's when you go, okay, this is the point where I may start practicing law. And something like an appraisal gap, what I see as a lawyer is you end up in problems because they're inartfully drafted. And even people that practice real estate law exclusively and people that do that all day, every day, there's wiggle room in their appraisal gap language. And if you're not trained in how to do it and it's not something you're doing all the time, it's really easy to make a mistake and create a big problem for your client. And so that's one of those times when you definitely want to go out to a lawyer. The same thing happens with rights of first refusal. If you're granting that in a contract, that's something you definitely want a lawyer to draft. And even when they're drafted by lawyers, they're really, really difficult to figure out. So any kind of funky provision like that, that's a situation that to protect yourself and to protect your clients, you want to be reaching out to a lawyer for help.
When a buyer is in a builder-developer contract and the builder is not performing, how is that addressed? How does the buyer approach to find out how to get out of the contract, et cetera?
Okay, so that's this will start to change. What I've been seeing most recently is that buyers are loving. I mean, the builders are loving to get out of the contracts because they can turn around and sell the property to somebody else for significantly more than they were under contract.
Yeah, I've actually seen the reverse problem where they aren't performing and they try to use a force majeure clause or some other provision to say, oh, sorry, buyer, we couldn't get it done in time and lumber costs are up and everything, so we're going to go ahead and terminate our contract and go do something else. So, and the buyer's trying to enforce it.
And those contracts, that also, when we were talking about situations where it's helpful to have a lawyer involved, one of the things that I skipped over was I was really kind of framing that in the context of real estate deals where you're using the Dora form contract. When you're doing that, there's a lot less concern over how's the deal going to play out, because all of the time and energy that's put into those form contracts is set up to be able to eliminate the likelihood of a dispute. When you're signing a contract with a builder developer, those usually are written by lawyers, but some of those I've seen are terribly written, and they're used over and over again by the builders, and they generally are more favorable to the builders than they are to the buyers. And unless it's a really well-written contract, when you get into a dispute, the advice that I end up having to give people is, I can't tell you what the resolution is because it's so poorly drafted. So if you have a big builder that is building thousands of homes around Colorado or the country, you don't really have that problem. But on smaller deals where it's a builder that may be building 1 or 2 homes a year, that's where you run into the problem, and where it really is helpful to have a lawyer to make sure on the front end that you figured out what the contract says and what it means, so that if the builder isn't performing, there's a mechanism for you to be able to get out. Because a lot of times those contracts will be so poorly written that you're trapped in a situation with a builder that's not performing, and you're trapped in a contract that doesn't help you. And when you're spending hundreds of thousands of dollars on the construction of a home, it absolutely is worth spending $3,000 to $5,000 on the front end in the same way that you would with a surveyor, to be able to make sure that the contract is well written and protects you.
You're muted, honey.
Sorry. If work done without a permit is disclosed upfront to the buyer and the buyer accepts it, so finished basement or additions were done without a permit, does that mitigate any liability?
Unless it would eliminate liability under the seller property disclosure form. So the buyer won't be able to come back and say that the seller lied on the property disclosures. So for the most part, that's going to protect the seller from the buyer. There can be weird situations where no matter what happened, the seller keeps the responsibility after closing. Those are pretty unique. Like I'm dealing with an example now where it's a septic system. So there are some weird situations where you might have liability that has nothing to do with the seller property disclosure form, but between a buyer and a seller, that should provide the protection that your client needs.
This was a question that came in regards to the builder contracts. So can we expect to see a crackdown on builder contracts anytime soon for builders having to start using DORA forms, or at least more standard forms? As Merc is saying, the contracts we have to use for new builds are terrifying.
I'm looking at Damien right now. He's shaking his head. I think that means the forms committee is not about to start drafting that form.
The problem is the real estate commission doesn't have jurisdiction over builders. I mean, they're principals. They can draft whatever the heck they want because they're the sellers. Just like you see the iBuyers have their own forms. You see REO properties from when banks had REOs, they were their own forms. If you're a principal, or if a party is a principal to the contract, they can draft whatever the heck they want. And the builders, there's just no jurisdiction. So there's no way to even pull them in unless there's some kind of legislation that was run that said somehow that builders were subject to the jurisdiction of the real estate commission. And I just don't see that happening.
Question here, do you believe there's any wiggle room or a limit to what agents write in additional provisions or amends? Are there some items that are mundane enough you believe a realtor can draft it, or do you believe anything written outside of the contract boilerplate should be attorney drafted?
Yeah, Merc and I might disagree on this one. So go ahead, Merc.
To me, there are, if you're changing dates, that's obvious. It's obviously there's no issue there. That's so anything that you would fill out on the contract, if you change it, there's no big deal there. Second, there are things that where there is wiggle room where it's not necessarily changing the rights of like something that changes property rights, but it could just be clarifying terms of the deal that I'm trying to think of what would be a good example, but it could be you're providing more specificity on specific items of personal property that are staying with the home or leaving. That's not a huge deal. To me, the places where I see problems most frequently are things like rights of first refusal, easements, oil and gas rights, water rights, right of first offers, the appraisal gaps, anything that is
Complicated.
anything that's complicated that you would have to go and do research on how to figure out how to write it. That's the sort of thing where you go, okay, I shouldn't be drafting that, and I need to bring in an expert.
Yeah, and my only, I agree with everything you're saying, Merc. My only thing would be this, that I think Conway-Bogue gives a broker a right to actually draft those additional provisions because it is in a standard form or the Real Estate Commission approved form. But what's important for brokers to know is that when you start drafting in additional provisions, you're going to be held to the standard of a lawyer. I mean, it's a contract. These are contractual provisions. And when you're practicing under Conway-Bogue, that gives you the limited capacity to practice law. You're going to be held to that standard. So what Merc's getting at here is that there are provisions that are especially complicated and preserve rights, such as, reserving the mineral rights in a property, or addressing the fact that water rights should be included, or what that looks like, or dealing with appraisal gap guarantees, or any of those others where you start to massage the terms of the contract or the rest of the deal, that while you might technically have the right to do it, you probably shouldn't be doing it because it could get you in a lot of trouble. That's what I think Merc's getting at. Now, we could argue about whether it's practice of law or not, or whether it's inside or outside of Conway-Bogue, and I'm sure Merc and I could have a great discussion about that. But you guys, you don't want to be in that position. That's, to me, the bigger issue is, you don't want to be like, oh gosh, we'll just do an escalation clause and we'll just draft this thing out. And then it turns out the escalation clause had something in there about providing offers or whatever the case may be, and nobody provided offers and they signed an amendment, whatever the case is. It could make it really complicated. You really got to think through if you're going to play in additional provisions. You have to run it to ground. And that means you have to think about every possible contingency, what could happen if it goes wrong, talk to your employing broker, maybe talk to your real estate lawyer about what that clause looks like to make sure you're not creating a liability for your client.
Are we okay to keep asking questions, or Merc, did you want to continue on?
No, I think this is great because a lot of the points that I wanted to make are
Perfect.
hitting on through these questions.
Okay, perfect. So this person is asking, the items you mentioned, like roof, solar, flooding, sewer, are you seeing inspectors being sued in this or being brought in on these items at all?
Generally no, because almost all of the inspectors have a liability limitation clause in their inspection reports.
Merc, you got to explain what that is, because they're not going to understand.
So when you look inside, so under Colorado law, you can agree by contract to be able to limit your liability. And in an inspection report, there almost always is a provision that says that the inspector's liability is limited to the cost of the inspection. So that means that their liability is limited to somewhere $400 to $800, depending on the cost of the inspection. There are ways to work around that so that you can pay more for an inspection where it has higher liability. But for the most part, inspectors are insulated through those liability limitation clauses. And I think what happens frequently is people call me up and they say, the inspector didn't catch this. This is outrageous. They should have caught it. I caught it. After the fact, I want to sue the inspector. And the first response is, send me the inspection report. On page 1 or 2, most likely there's going to be a provision where you agreed to limit their liability to $800, and you'll spend more than that making a threat against them. And those provisions are enforceable, even though they don't feel like they're fair.
Very good point.
Doesn't the obligation of disclosure of adverse material facts also pertain to brokers and potentially draw in a broker who may know something that the seller fails to disclose?
Yes. So that's this is one of the few ways where a seller broker would have duties and obligations to a buyer, so that if you know something and you fail to disclose it, then you can have liability to the buyer.
This is a big subject. Any recommendations relative to escalation clauses, pros and cons? Somebody commented escalation clauses are of the devil. Yuck.
Yeah, I don't like them at all, but you know, if I'm a seller, I don't think they're very effective. But Merc, why, instead of us talking about recommendations or anything, have you dealt with these when buyers or sellers come in as far as the escalation clauses? Maybe you can talk about what it looks like from a client perspective if you've seen them.
That's actually one thing that I have not. No, that's not something that I have a ton of experience with, and I don't think I've ever had a single dispute over an escalation clause.
Yeah, they usually get resolved before they get to you, I'm sure. So as the brokers fight over whether it's effective, not effective, what's the price, what isn't the price, et cetera. So let's go to the next one.
Okay. Do you ever see seller suits filed against appraisers?
Not, that's also one that's not particularly free. The one place where there was a lot of litigation against appraisers was 5 to 10 years ago. There were a lot of suits against appraisers that had done valuations of conservation easements. But in the real estate arena, for the most part, no.
This was a question regarding some of your comments. Is there differences between transaction broker versus the agency agreement?
So if you're acting as a transaction broker, some of the things that I said where you would have, where I'm saying you've got to be the eyes and ears of your clients and you want to be looking out for them. That's really, when I'm thinking about that, I'm thinking of it more in the traditional agency agreement rather than in the transaction broker agreement. So in the transaction broker agreement where your duties are really limited, there's a different approach. That's really how much value do you want to provide to the two people? Do you want to be totally standoff and not be engaged at all, or do you want to push a little bit farther?
Yeah, and be careful, guys, that think that, you know, transaction broker just means that I have less liability. That really only works as long as you really are taking that hands-off approach to the transaction, because guys like Merc can figure out how to drag you in under, if they can point to the finger saying, look, you were acting as an agent, look at all the things that you did. So, you know, be careful if you're trying to make a distinction there that you are staying in the lane that you're supposed to stay in.
This broker's asking about using the clauses that are provided in CTM, going back to our discussion from a couple minutes ago. That's okay to do.
And I will talk about that because I'm sure Merc probably doesn't have any idea what that is since he doesn't probably do CTM or know what that is. But so CTM, the clauses that are provided they should be from lawyers that drafted them on behalf of either you as the broker or your brokerage firm. Double check what clauses are in there, but a lot of times those clauses are provided. I know I provide clauses to my clients. I know that Frascona, Joyner, Goodman, and Greenstein has put together clauses for some of their clients as well. But you want to make sure that you're not just stealing clauses from what some other broker drafted that you're putting in there that has problems. Make sure that it is coming from, that those clauses in CTM are coming from a lawyer that drafted them on behalf of you or your brokerage firm.
And then there's a question that popped up here regarding issues with conservation easements. I missed that if that came up earlier.
Oh, Merc was talking about the suits that were over against appraisers over conservation easements. Go ahead, Merc, if you want to briefly talk about that.
And that what happened there is that the conservation easements were used for tax write-offs, and so there was a big issue about the validity of the appraisals and the tax implications. That was kind of a niche issue that came up that has, I think, probably mostly been resolved because of all the litigation that flowed out of that.
Terrific. That's all the questions that we had in the Q&A. Anything else, Merc, that you'd like to add to our discussion today?
I don't think the only other thing was just one of the other pieces of advice that I like for brokers to have is you had actually just said it, make sure you stay in your lane. And where I see people getting into problems is when they get out of their lane geographically. So if you specialize in one part of Denver, thinking that you're going to provide great service in Boulder or Elizabeth or Fort Collins, even though you may have a relationship to be able to get a deal done there, whether it's on the commercial or the residential side, the unique geographic, that's one thing to be really wary of. The second is, just because you're really successful at residential doesn't mean that you're going to be successful in commercial, even if your residential deals lead to a commercial deal. So to me, it's the lawyers are the exact same way. There's no way that I could specialize in real estate and intellectual property or a lot of other areas of law. And real estate brokerage to me is really similar. And you stay out of trouble and provide better service to your clients, the more specialized you are.
Now, that's a great point. Thanks, Merc. And that goes back to competency, which the Real Estate Commission has really been looking at lately with the investigations as far as whether brokers are competent in the transactions that they're conducting.
And then, Jill, I just wanted to thank you and everybody at Heritage for putting this together. When I was saying earlier that it's a credit to the brokers that we have as many deals get done, it's also a credit to people like your team at Heritage that make all those transactions happen. And one of the reasons that a lot of lawyers don't have to be involved is because of the work that you all do. And it's the fact that our system functions the way that it does is a big credit to brokers and to the title companies.
Thank you for that, Merc. And thank you so much again for your time today. You are a brilliant attorney. We really appreciate all your insight and your time. And this was super informative. I know everybody really enjoyed this and got a lot out of it. We've gotten a ton of great comments already. So I can't thank you enough for taking the time to spend with all of us this afternoon. So
thank you for having me.
All right, thanks,
thank
Merc.
you.
We really
Thank you
appreciate
so
it,
much,
guy.
everybody, for joining us. We were so glad to have you here, and we will see you next month.
Sounds good.
All right. Thanks again.
Bye.